Hello and welcome to Money Tips. This is Charles Kelly. Today I want to talk to you about the new laws that are coming into effect, which will affect landlords and property owners, people renting out properties. I was actually at an NLA, or National Landlords Association, meeting last night, and they're a very good organisation actually. I'm not particularly pushing them, I'm just giving them a little plug here. They're like a trade body or a trade association for the profession, for landlords. And I think if you're in any business or any profession, you should be a member of your trade body. You know, solicitors, accountants and nurses and doctors, they all have their trade bodies. So you should be in this, and it supports them to support you and support others. The NLA give out a lot of information, they have meetings all over the country, and they also have a helpline which they receive, I think it's thousands of calls every month from obviously anxious landlords needing legal help or pointers on Section 8, Section 21, and I'll come on to that in a second. But in particular, I want to talk about some of the things they mentioned last night. One is the new Tenants Act, which comes into force from the 1st of June, which bans charging tenants, and if you do charge them, then for certain things, then you could be fined up to £5,000, and there's criminal offences for repeat offenders, and allows civil penalties of up to £30,000, and that comes into effect from the 1st of June. They also said that it doesn't matter, even if your letting agent is charging them, say for a reference, for instance, you, the landlord, will be responsible, and that's what they said. That's their words, not mine. So you've got to watch out for that. And they went through a list of what can and cannot be charged to the tenants. One was obviously rents and utilities. Rent arrears is another one, and you can charge interest at 3% above the Bank of England interest rate, and applies after 14 days of late payments. You can charge a holding fee, 1 week's rent held for a period of up to 14 days. You can charge for a replacement tenant mid-tenancy. This is where a tenant decides that halfway through a tenancy agreement they want to bail out. And you can charge a replacement tenant's fee of £50. I'm sure that will go a long way to help people. Lost keys or security devices you can charge for, and you can charge for up to 5 weeks deposit, 6 weeks deposit if the rent is £50,000 a year or more. So that's the maximum deposit, in other words. And you can charge a surrender of tenancy. Tenant pays the remainder of the rent. So watch out for those things from the 1st of June. And make sure that your letting agent knows about these things, because I was at this meeting last night. There were 50, 60 odd people. There was only one letting agency in there, and there must have been dozens around the area. Only one turned up, and she was very switched on. And I talked to her about this afterwards. I said, what's going to happen? Well, these fees are going to have to be passed on to the landlord. Someone's going to have to pay it, because, I mean, she had an example. She gave me an example of a tenant that wanted to move in a couple of weeks ago, and they said, yeah, we're going ahead, and they initiated the referencing process, and they pay a company to do the referencing, and then the tenant after a few days said, no, I've changed my mind, I don't like it anymore. So what can you do? The money's gone. Trying to get the money off the tenant would be a job, would be an issue. So there's going to be problems with this act. I know that in the past maybe tenants have been abused by certain unscrupulous letting agents, but it's also going to cause problems going forward on this. So I don't know what's going to happen, but that's the law. Look it up, and if you're not sure about all the details, go onto the NLA website, National Landlords Association. I'm sure you can Google that. And then we talked about the new Section 21 abolition consultation. Now, the government talked about this. I mentioned this in a podcast a few weeks back, that the government is proposing to abolish the Section 21 notice, which just gives you, as a landlord, the right to say, well, I'm serving notice on you to quit the property because we've reached the end of the tenancy. I don't know why you need this. In any other contract, you have a beginning and an end, and at the end of the contract, people say, thank you very much, have a good life, nice knowing you, goodbye. But for some reason, in this case, we need to serve notice. And I asked the letting agent, why do you all serve notice? And they said, well, you never know. I mean, you could get to the end of a tenancy, 6 months or a year's tenancy, And if you haven't served the notice, the tenant can say, well, I've got nowhere to go, and then I want you to serve notice on me. Therefore, you would then need another period before you could get your property back. But what the government are proposing to do is force people landlords to use Section 8 grounds, and where the landlords will need to apply for possession of their property under specific grounds. And normally a Section 8 would be used where a tenant hasn't paid rent, and then you need to produce specific grounds. But really, why do you need to produce specific grounds like, I'm going to move back into the property, or I'm selling the property? Why should the onus be on the landlord to give those grounds to the tenant? Why can't the tenant just move? Well, that's another subject. But that's what the government are going to want to do, and what the NLA are pushing is that they want you to join in on their petition to the government and actually petition the government against this. So at least we could influence the government on these grounds. So if you go on the NLA website, you can sign up online for their petition. And actually last night they had these little postcards which we all wrote out, and they're going to go to Number 10 and present the Prime Minister with these. Now there will be a new Prime Minister coming up very soon, so maybe this minister might have more sympathy with landlords. And it's not just about them and us. We want a system that is fair to everyone. I'm a landlord also, and I want a system that is fair. Touch wood, I haven't had too many troublesome tenants, but you get the odd one that says, no, I'm not moving, I want you to serve a Section 21 notice. They think that if they're evicted, that they can go to the council and then get a council flat or accommodation from the council. The council were at the meeting last night. The meeting was at a borough council called Hertsmere Borough Council. They sponsored the venue and the meeting, and they said it's not the case. If people cannot intentionally make themselves homeless and then go to the homeless unit and then say, well, I want to be housed. However, one of the landlords in the audience said, if there are children involved, then it doesn't matter, because they can still get housed by the children's department. And the council said, well, that's another department, so that's another thing. So I think the government needs to think about this carefully and really make sure that they've thought this through fully before they start messing around with rules that have worked quite well for quite a long time. The other thing they mentioned is that a Section 121 notice, as it stands today, are invalid unless the gas safety certificate has been given to the tenant before the tenancy agreement has been signed. That's before. Now they're recommending at least 1 day before that you present the gas safety certificate to the tenant. I expect what normally happens is that the tenant is presented with the pack by the agent or the landlord and said, here it is, here's the gas safety, blah, 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 right, sign here, and and off we go. But apparently there was a case recently, Caridon Property Ltd versus Monty Shooltz, and it said that the judge ruled that any Section 21 notice is legally invalid if a gas safety certificate is not served before the start of the tenancy. Now this cannot be rectified later on, so if you've made this mistake, just watch out, because you can't just say, well, I'll issue a new tenancy now, a new contract, and that will change everything. Because if you go in with a Section 21 notice, the judge will normally sit down and say, right, where is the original tenancy, where's the last tenancy, and they will go from there. So now the NLA again are pressing the government to perhaps rethink this and see what they can do with, but it would take legislation obviously to do that. So 2 points there. Look out for that. Section 21, and particularly now if you're going into a tenancy, make sure the tenants have all the information like the gas safety certificate before the tenancy is signed. I know it sounds like a nonsense, but you don't want to get to a situation later on down the road where you're in trouble and you can't get possession of your property, or there's issues there. And what they've said is that effectively they will treat your AST, or assured short hold tenancy, would be effectively treated as an assured tenancy if you haven't complied with all of those rules. So watch out. And this is why I think you need organisations like the NLA to be on your side if you're a landlord, because they can cut through all of the legislation and give you simple advice. because again, it's not about them and us and that sort of thing. It's about being fair and making sure you've complied with the rules and being fair to the tenant as well, and being a good landlord and knowing what the law is, because you don't want to get caught out. And they also advise that in cases where Section 8 are used, average fees involved with the Section 8 can amount to something like £5,000 and can take months to go through. So you don't want to get into a situation where you have to serve that, and you need to know what you're doing, really. You really do. And you need to know that your letting agent knows what they're doing, because if they're not keeping up with these changes and doing their CPD, their continuous professional development, then they're going to get you into trouble, because you, the landlord, will be ultimately responsible. Now, there's also a new rule coming in, or proposed new rule, where landlords will be legally required to join a redress scheme. This will make it easier for tenants to claim compensation. Now, there's no redress scheme for landlords. This is for tenants, by the way. And landlords could be fined up to £5,000 if they do not join this redress scheme. It's like a compensation scheme, or a scheme where it will make it easier for tenants to go and claim compensation. Now, if we don't do this as an industry, then the government will bring in one which will be far more onerous, I expect. Implementation date is unknown, but a working group will now be formed to flesh out the details and conditions. Now, the NLA are proposing that they could form a redress scheme which would be fairly inexpensive, because if all the landlords joined it, then it could be done for a minimal cost, or maybe as part of their membership fee. And I think that's a very good idea, and I hope that can come to pass and they can do something about that. Other things were mentioned last night at the meeting were the end of the section, the section 24, and this is where interest tax relief has been phased out for interest on buy-to-let mortgages if you're borrowing as an individual borrower or a partnership. And a lot of people in the audience didn't know about it. It was unbelievable. He said, "Can I show of hands if anybody knows about this and is aware of it?" And yeah, a few smart, savvy landlords put their hands up, but a lot of people were saying, "What is Section 24?" In fact, I think one of the people from the council didn't know about it, and he's in the property section of the council. So it's something that will start to bite, and landlords are going to feel it soon in their tax bill, where they've lost that tax relief on their mortgage interest relief, and they've lost the wear and tear allowance, which used to make quite a bit of difference on your tax. So just watch out for that, and you might see more landlords selling or pulling out of the market, and as a result of these rule changes, because they might just say, well, it's just not worth it. We've got this, we've got selective licensing coming in, we've in various boroughs, we've got Section 21 possibly being abolished, we've got Section 24 coming in, taking away, we're literally taking money out of our pocket. So a lot of landlords might decide that they've just sort of had enough of it all and get out and want to sell. And I think it will probably, you'll see a situation where the more professional landlords, I say professional, I mean bigger landlords that want to stay in that market forever and getting out of it, rather than the accidental landlords who perhaps came into it because they inherited a property or rented out their property because they couldn't sell it while they bought another one, and they're probably people that will want to maybe get out of the market. So we'll have to see how that develops over the next year or so, but certainly landlords and property owners are going to find themselves with bigger tax bills in the coming months, certainly by the next tax year, when they start paying their tax next April. So that's it really. If you are a landlord, once again, join a trade body like the NLA or one of the others. There is another one, quite a famous one, I can't remember it at the moment, but I would join them, because they've got information there on say tenancy agreements and that sort of thing, because you could be using a tenancy agreement that you've used for years and find that it's out of date. It shouldn't be used anymore. So just make sure you keep up to date with that. And if you've got any questions on property, or you would like to go to a property course to learn more about property investment, I met a guy last night who'd come over from Paris and he wants to invest in London. So I've put him into a property course that he can get onto, and he can do a one-day taster and then decide if he wants to go deeper into property from there. And he was amazed. He said he didn't know these things existed because he went to this meeting to find out more. And so if you want to go on a property course to learn how to do it properly and learn from professionals, then drop me a line or click on one of the links maybe on the attached blog to this post, and I'll put you in touch with those, because it's well worth doing that. Even if you're a landlord for years, do join, because the people who say I've been doing this for years, I don't need to go on these are the people who really need to do it, because they're perhaps have lost touch with all the changes in the market, and the fines can be quite significant if you get these things wrong. And also, if you're developing properties, if you want to do a HMO, for instance, you need to know the rules. You need to know how to apply the rules and what to do before you sort of convert a property and then find that maybe some of the rooms are too small, or maybe you haven't complied with the fire regulations, and then you don't get the license, or you go ahead and let it and find you're doing it illegally, and then you end up getting a big fine. So just watch out for that, and drop me a line if you do want to get on a course so you can learn how to become a really super professional landlord, and be good to your tenants, be good to you, be good for your profits, and do the right thing. So thanks very much for listening. This has been Charles Kelly, bringing you money tips to help you save, earn, invest, accumulate, and ultimately enjoy more money.